Yeah, let's start with the Pledge of Allegiance. Everybody, please stand.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
You shouldn't be the loudest. I can say it right.
Yeah, I'm loud.
I'd ask if anybody's going to testify to stand up again and be sworn in.
If you're going to speak, you'll need to be sworn in, please. You'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth so help you God? Thank you.
Okay. Does anybody have any revisions to minutes of last month's meeting? Corrections or motion to adopt? I'll move we adopt the minutes.
Seconded.
All in favor?
Aye.
Motion carries. Staff, do we have any revisions to this month's agenda?
I'm not sure if it's so much a revision, but my first two cases, A and B for Charles Sullivan Sr., there's a request for a continuance until June. He's retained attorney who's out of town, and the city has no problems with that.
Does that require any action from us? Or?
Probably should go ahead. You probably should go ahead and grant the continuance, because that's what Sherry was able to give a 30-day continuance with your approval, but anything further the board has to approve, so you probably should go ahead and vote on approving that to the June meeting.
All right, we'll do that. You got anything?
Case 16 CE 6520.
Wait, did we have a motion and second and vote on it?
Not yet. We're not done with all the
Oh, okay.
changes.
So we're going to do that next,
Yeah.
after the changes. Okay. Yeah.
Can't keep up.
16 CE 6520 Jungle Club Sports Complex is being removed from the agenda.
Which number?
16 CE 6520 item P.
And the
okay.
reason, please.
Item L. Yeah.
P. L. Okay. L.
No, who's confusing us?
Legal issues between a vendor and the owner of the club.
Is that it?
Postpone it?
Removed.
Remove it.
That case was withdrawn, is what I was looking for.
All right, I'll make a motion. We accept the agenda as modified.
Second.
Seconded. All in favor? Aye.
Aye.
All righty. Start with case 16-CE-6515, Studio 14 LLC.
I want to go there. I'll start. Yes. 16 CE 6515, Studio 14 LLC, was cited as a repeat violator for 2 temporary on-premise signs placed out during non-business hours at 1962 14th Avenue. A citation was issued on 3/11/2016 with service of the citation provided by certified mail. Mr. Redfield is here today to appeal the citation.
Okay.
Could you state your name and address,
Sure.
please, for the record?
My name's Scott Redfield, and I'm one of the owners of Studio 14.
Thank you.
On February 29th, a courtesy letter was sent to us from Melody Sanderson. February 29th was a Monday. Received it on March 7th, which was also a Monday. We immediately complied. On Thursday night, the 10th, the sign was left out. On the 11th, we got a citation for $200 for a second offense. Ouch. For a sidewalk sign. The first citation occurred almost 2.5 years ago, and that was on August 4th, which was a Sunday, at 12:59 p.m. I immediately called Mrs. Sanderson and
Actually-
said, pardon me?
That was Officer Keiki.
Oh, I'm sorry. I've got the letter was signed.
Okay, wait, you're talking August? Never mind, go ahead.
Yeah, I'm talking August 4th, 2013.
Okay, that was Officer Kiki? No? Or is that me?
I don't know.
Okay,
It says issued
Wait a
by,
second.
issued by
Wait a
Melody Sanderson.
okay.
This was issued by Melody Sanderson
Okay,
on August 4th, 2013, which was a Sunday, and it was issued at 12:59 p.m., just a minute before 1 o'clock. I called after I got this notice and said, we were open on that Sunday, and we were. She talked to, I'm not sure who, because I didn't make a note of it. It was a gentleman, I suspect her boss at the time.
McGarry.
Pardon me?
It would be McGarry, head of planning.
Okay, McGarry. His remark was, pay the citation. You didn't have any scheduled classes. We have classes throughout the week. This is not our hours of operation. This is our schedule of classes. So the first citation 2.5 years ago was unjust. This one was just, but it should be the first citation. We did leave the sign out overnight. Forgot to bring it in on Thursday night. So the first citation was during our hours of operation. This one, we blew it. But again, $200 for a sidewalk. I'm a local business guy. I struggle to pay my bills. And this is...
The way the sign is calculated is it's $50 per sign, and if it's a repeat, it goes to $100 per sign. So in light of the circumstances Mr. Redfield is presenting, staff would go with the $50 citation.
I have a question for Melody. How do you determine whether the business is open or not when you find the sign?
This citation was issued because there was no one in the building when it was out.
Right, but the first time, if he says we're open,
At that point, it did not appear that they were open. The building didn't have anyone in it. The door was locked.
No. On Sunday, August 4th, we were open.
Okay, I think we also said that you do imagine that is also, you're open during that time frame, so.
Sure, but we do personal training. Sometimes we're early as 6 o'clock in the morning, and unfortunately there till 10 o'clock at night. That wasn't the case here. I mean, we were closed. We were caught with a sign out.
Right, no, we understand that.
Yeah.
We're on the same page.
the normal procedure is to knock on the door or try to open the door to see if they're open.
Correct.
Okay. And
So what you're saying is it should be $50?
I'm saying in light of the circumstances, yeah, we'll go
Yeah.
for 50.
Well, I think that's fair since you've admitted to
Pardon me?
mess it up. I think that's fair since you've admitted to screw it up on this one. So.
I make a motion that we give them a $50 fine.
Second.
Okay, all in favor?
Aye.
Aye. Anyone opposed? Motion carries.
Thank you very much.
Thank
I
you, sir.
appreciate it. So I'm guessing that because the first violation was over 2.5 years ago, if we have another violation 5 years from now, it'll be a second violation.
More than likely.
Yeah.
do you have a sign that says whether you're open or not?
No. This schedule,
So
if you did the citation and you took a picture of this when you
I included that, yes.
included, this is the one she took a picture of. It's a class schedule.
You've got it.
You know, we're open the second Sunday of every month because we show a movie.
yeah, but how is she supposed to confirm whether you're open or not? If the door's locked and the lights are off?
But that may have been the case on Thursday, the 10th, or I would say Friday morning, the 11th, but it certainly wasn't the case in August.
So in the future, if your sign's out there, that means your door's unlocked and you're open, your lights are on.
Yes, the lights are on. The door may be locked if we're working with a client. Like if we have a massage client at 1 o'clock and I'm the only one there, the door's locked, but there's a doorbell right there that says, if locked, ring bell.
Okay.
Okay?
Yep.
All right,
So-
Thank you.
do I get a notice to pay this fine, or what's the?
The board will issue an order that'll give you a notice to pay.
Okay, thank you very much.
Mr. Chairman, did the board vote on that?
Yes, we did.
Okay.
It was unanimous.
Thank you.
Okay, case 15-CE-6314. Can we combine this with the next one as well?
Continue. Those two will continue.
Are we on?
Yeah, we need to.
That's the Sullivan.
Still vote on it?
That's A and B.
Yeah.
That's,
I thought we did that already.
yeah, we didn't vote on it, or you didn't vote on it. Hang on, and I'll give you the date.
Continue till June
It's June
8th.
8th, it says on.
If we continue to June 8th, what happens to the fine? Or is there a fine, or what goes on?
There isn't a fine. He has retained an attorney based on the warning.
Okay, it's a warning that he had.
Correct.
Okay.
He's not accruing fines at this time.
Right, it would be June 8th, would be that meeting in June. So you would need a motion second and a vote on that.
I'll second it.
Make a motion.
Well, I make a motion to drop that. I second it.
Okay.
On
So
the first case, do we need to do separate cases?
that's what I was asking. Can we just?
No,
vote?
you could do that with
Okay.
both of them with
All
one
right.
vote.
Everybody in favor of moving this to June 8th?
Aye.
All right. Anyone opposed? Okay, motion carries. Case 15-CE-6060, Venetian Apartments.
This case came before the board, and they extended the time. They started working on replacing railings at a two-story apartment building. Due to safety concerns, they started prior to obtaining the permit. They have a permit under review through the building department, so we're just asking to continue the case since they're in the process.
Okay, just until the next meeting, or do you think you need longer?
Next meeting would be great.
All right, I'll make a motion.
That would be May 11th.
I'll make a motion that we continue this case until the May 11th code enforcement meeting.
I second it.
All in favor?
Aye.
Aye. Motion carries. 15-CE-6276, Titone Properties LLC.
Titone Properties LLC, Mark Titone. He was cited and found by this board to be in violation. Excuse me one second. On 12/29/2015, with a $50 penalty and a request for correction for violating the Code of Vero Beach Code and Ordinance 38-31B5. You heard on February 10th, you found him in violation. He was ordered to correct the violation, pay citation, and city costs. The violations were corrected, and the case is deemed complied as of March 1. What we're requesting is the board order finding compliance and ceasing penalties as of March 1, and his penalties and costs accrued to be paid.
And how much are those?
We don't have it calculated.
That would come through the city clerk's office. We don't have an amount yet.
It's $50 per day that was commencing from January 28th to, it was found corrected on March 1st, though, so it would run through the end of February. And then the costs were $6203, is that correct?
Again, yes.
That's
From
That's what was in the
administrating-
board's last
Yes.
order. So it just needs the board to find it corrected and impose the continuing, the initial and the continuing penalties through February, is it 28th, 29th?
So moved. Anybody second?
I'll second it.
Okay. Everyone in favor? Aye.
Aye.
Motion carries. 15-CE-3315, Andrew F. Zaleski.
This gentleman was cited a citation on 12/11 of 2015 with a $50 penalty and a request for correction for violating city ordinance of having a home occupation without issuance of his business tax receipt and vehicle sign code violations. You heard the case on February the 10th. You found that he was in violation, and he was ordered to correct the violation, pay citation, and city costs. It was determined after the fact that he did in fact have his BTR 2 days before this hearing. He has paid the citation. The city is requesting that we waive the costs associated with this case and find the case is complied.
So there are no fines?
Correct.
Okay.
In other words, the board is going to, the prior order was ordered to correct violation, to pay initial penalty and costs.
And he's done that.
And he's done that.
He's paid for the
Continuing
citation.
penalties were not requested
Right.
in the last order. So.
Right, he paid the initial $50 cost.
Okay. I'll make a motion that there was a violation and it's now in compliance and the penalties have been paid.
Second.
All in favor?
Aye.
Motion carries. 16-CE-2235, Laura L. McCluskey.
Case number 16CE2235, citation number 0910T for Laura McCloskey. This is a vacant lot that was once built upon. The home has been removed. She's been cited for weeds, grass, and overgrowth in excess of 12 inches. Ms. McCloskey's had several issues in the past. She's always taken care of them. For whatever reason, this time I have not been able to get a hold of her. I have posted the property. I did post it with her citation and with her notice of hearing, and I've heard nothing from her. I'm requesting the citation payment of $50, no continuing penalties, and I'm asking that you allow her 30 days to remit the payment and to satisfy my need to have it mowed.
Okay.
We haven't been able to locate her at all.
Everything I've tried's come back.
Is she deceased or anything?
I don't know. I can't find her anywhere.
But she is elderly.
And again, she's had problems in the past as far as getting it done, but every time I've ever sent her anything, immediately she's on it.
Right.
This time the things are coming back, so I'm not sure what, and it was a P.O. box. So
See-
it's not, I don't have another address other than a P.O. box for her.
You want the penalty to take effect after 30 days?
Correct.
Okay.
I want to give her an additional 30 days to do it.
Well,
It
if you're
sounded like he wants the penalty to be imposed if she hasn't done anything after 30 days.
here's what I would suggest is bring it back next meeting, and if it has been corrected by then the officer may be asking for continuing penalties. Is that okay, Tom?
That's fine. And I was hoping to waive the continuing penalties.
Well, I understand you're not asking the board to do that now, and they don't have to impose the continuing penalties. You can just order it to be corrected within 30 days, or actually, let's use I'm sorry. Well, if they go ahead and issue the order to correct, might be helpful. Let's see what a date would be.
We'll do that.
The next meeting is May 11th, so perhaps the board might consider ordering it corrected by May 6th. That's the Friday before.
Okay. I'm okay with that.
Anyone want to make a motion?
Make a motion, we delay until May 6th and give her till May 6th to get it in order, and if not, then we give her a penalty of $50 and bring it up at the next meeting on May 11th.
I'll second it.
All in favor? Aye. Motion carries. Okay. 16-CE-6440, Cottonways Incorporated.
Cottonways was cited for a sign violation. The violation has been corrected. The penalty remains unpaid, asking the board to fine for the $50 initial penalty.
All right, I'll make a motion the board issue an order to pay the $50 civil penalty.
Second.
All in favor? Aye. Motion carries. 15-CE-5775, Bank of America.
Citation number 0667T. This case was heard on August the 12th of 2015 by the city. They were ordered to pay the citation, costs, and continuing penalties. The violation was corrected as of September the 28th, 2015. However, for whatever reason, the case did not come before the board finding compliance. Today, I'm asking for a finding of compliance on September the 28th, 2015, and to report to you that the city clerk has received payment for all the citation, city costs, and penalties up to this point.
And that total is $3,306.52. So if you'd impose that in your motion, that'd be great. All penalties and costs encompassed therein.
Okay. I'll move that the board issue an order finding there was a violation that's been brought into compliance as of September 28th, 2015, and that the fees and costs of the city of $3,306.52 have already been paid.
Now, does this take care of 6407 as well?
No, it does not.
Does he need to issue an order to pay that?
Yes, it would be to pay it, and then
Right.
she's got the
All
payment.
right, I got you. Can you change that?
I'll change.
All right, thanks. Anybody
I'll
want-
second.
Thank you. All in favor? Aye. Motion carries. Next one, 16-CE-6407, also Bank of America.
Same home. Going forward, it was found in violation again on February the 10th. That's how we discovered that the initial one had never come back before you. But in any event, it was in violation again. It still is for weeds, grass, and undergrowth, and trash and debris throughout the property. A citation was sent certified and signed for by the Bank of America on February the 17th. As of April 13th, 2016, no corrections have been made and no citation has been paid for. Excuse me, it has not been paid for. Today I'm asking for a finding that a violation does exist and an order to correct be issued with citation, continuing penalties included. They are aware. We just received the check for the last one. I've called them up. I did make them aware. Listen, we've got another one. They said, we'll get to it when we get to it. So that's where we're at. I assume in a month or two we'll probably get a check for that one too, I guess. I don't know.
So as a repeat violation, you
It is a
want us-
repeat, but again, I didn't know that at the time. I thought they satisfied it last time, so I cited them as a first time. And in lieu of amending it and going back to the bank with a new amendment order and everything else, I thought for $50 it would behoove us just to let it lie as is and go forward from there.
So the continuing penalties need to start on February 10th?
Correct.
Okay. Do you have any cost?
Not yet. It's still not final. So it's still not complied, so we don't have a cost yet.
The cost of enforcement, I think.
No, I waived that.
So do we just continue this until
No.
violation is?
Yeah, this would.
We need to make a motion finding a violation and issuing an order to pay the $50 penalty and imposing $50 a day continuing penalties.
And ordering the property
And ordering
corrected.
correction, yeah.
Do you make that motion? I'll second it.
Trying to school you guys here, come on. All right, I'll make a motion finding the property is in violation since February 10th, 2016. The violation continues, and the board issue an order for payment of the $50 civil penalty, $50 a day continuing penalties, and that the violation be corrected.
I'll second.
All in favor? Aye. Motion carries. 16-CE-6457, Maxwell Properties.
In regards to this case, Maxwell Properties Incorporated was cited for site plan approval required for new and/or additions to outside storage. A citation was issued 3/3/2016 with service of the citation provided by certified mail. Mr. Maxwell is here today. I'm sure he wishes to weigh in.
Would you like to step to the podium?
This is a little complicated.
It's never easy.
Well, I've got a notice of hearing, and it's a different number than yours. And they said it was already taken care of on this number. I sent Mark to give the $50. They said it's already been taken care of. They didn't take the check, so I thought it was okay. So I guess it's for another case. So anyway, we've been working to get it done. I think it's complete. You've been taking pictures. I think we're all in compliance. I don't know what.
We are not in compliance. As on the citation, you need to sit with the planning department and do a site plan review for the property. All the tenants have all their stuff all over, and as it said in the citation, please meet with the planning department to follow your site plan.
Well, we could never get with anybody here. We've been here 3 or 4 times to meet with you guys to do it. I've got the plan here. It's original. It's been a car lot since 60. And here's the plan, and the parking is used by different people because there's like 6 different, or 7 or 8 different people in there. The church, the bail bonds, the auto guy, the mechanic shop, and they all kind of share it. I can't just give them certain spots. And why do I need that?
That's a requirement by the ordinance by the planning department, so that would be a planning issue.
Who's the planner? Who do I take? Who's the planner?
The planning department, there will be a planner of the day that you can sit with, and they can pull the original site plan.
Department?
The planning department upstairs.
Well, we can't ever get in there.
No, I was there, about 2 weeks ago, and the lady upstairs.
I'm sorry, sir. What is your name?
My name's Mark Peruzzi. I was
he'll weigh in if he wants
up
to.
there 2 weeks ago, and I was getting yelled at by the lady up there. Then Mr. Maxwell called the mayor, I believe.
Right.
Yeah, she was actually yelling at me up there. Tell her to get those cars off the property now, screaming and yelling at me up there. I'm just representing, find out what you want us to do, and she's yelling at me. So I left. I don't need to get yelled at for asking for
Then
advice.
perhaps today, while Mr. Maxwell is here with the plan, he could go upstairs and meet with the planner, and we can continue this case.
Maybe you could help him out?
Absolutely.
Great.
Because I don't know, we can't seem to get anywhere. We asked for a meeting. I called the mayor. He called one of the deputies, and they were going to have a meeting 2 weeks ago on Monday. Yeah. Nobody ever called, showed up. I mean, just not getting anywhere.
Do you have maybe an extra hour after we're done here that you could go up and meet with everybody today and get it all taken care of?
I'm ready to get done.
I think we can make that happen for you.
Okay, that's fine. But, we're just not.
You've come to the right place.
Yeah.
Everything's right here, except
Good.
the building department, and I don't know if they need to pull a permit. It's just city site plan review, and they'll look at it and approve it, or give you their comments, and you need to come into compliance with the city of Vero Beach.
And they'll take your money. Don't forget that
And
one.
they'll-
Can you check your microphone, please?
Hello? It was off.
Okay, yeah, but I don't know all the different businesses. The church has people that on Sundays that come over and they use this spot. So I don't really.
But you own the property. You own the property as a whole.
Right.
Okay. You're responsible for the whole property.
Right.
And then meet with them and get a project site approval.
Okay. Well, I don't know what that good's for, but.
All right. We need a motion to
Continue.
continue this.
May 11th.
That'd be May 11th would be your next meeting. Hopefully it could be resolved by
Continue
then.
this till May 11th.
Tim.
I'll second it again.
Okay, moved and seconded. All in favor?
Remind Tracy that they have pictures.
Here we go.
Here.
Is anybody upstairs now? Or?
Yeah, I'll take that there. One second, I'm done, so.
Okay, thanks.
Great, thank you.
Hey,
Thank you.
Tom.
They'll help you.
Hope so.
Yeah.
it should.
The problem is there's like auto repair, so there's junk vehicles, there's a U-Haul business that hasn't been approved to have display.
Melody, you probably shouldn't discuss it further without
Okay.
them in the room.
Oh, good day.
You too.
Thank you. Okay. 16-CE-6432, High Tide Autos.
Requesting a board order for 166432 High Tide Auto was cited for not having a current business tax receipt for the repair and sale of motor vehicles and needing site plan approval for the property at 2626 U.S. Highway 1. A citation was issued 3/3/2016 with service of the citation provided by certified mail. No request for a hearing on the citation has been received, so a hearing to contest the citation has been waived and the violation is deemed admitted by the violator. The violation has not been corrected as of today, and the civil penalty assessed on the citation has not been paid. No enforcement costs are requested by the city. If the board finds a violation exists, we request that the board authorize the issuance of a board order in the case for the initial penalty, continuing penalties for the days the property is not in violation.
Okay, so they have not yet applied for a business tax?
Correct. We've had no contact from them.
Are they in operation?
Yes,
So they've neglected to do anything.
we have not heard from them. That is correct.
Well, you want us to make a motion to continue it?
No.
No.
If you find that a violation exists, we're asking for the initial penalty and continuing penalties.
And to correct the violation.
All right.
We always forget that part.
Make a motion that they find that they're in penalty or in violation, that they are due the initial penalty and continued penalty until they obtain they are in compliance. Is that all right?
Continuing penalties till they come into compliance.
And to correct the violation.
And correct the violation.
We always forget that part.
I second that motion.
All in favor?
Aye.
Motion carries. 16-CE-6413, Matthew Martise.
Mr. Martise was cited for weeds, grass, and undergrowth at a height of more than 12 inches at 2020 Delmar. The property is in compliance as of 3/30, asking the board find the property in compliance and order for the initial penalty of $50.
No cost.
No cost.
No continuing penalties?
No continuing.
But it's been corrected, right?
Correct.
There was no prior order, it doesn't look like, so this would just be an order to pay the civil penalty on the citation of $50.
I'll make a motion that there was a violation, the property is non-compliance, and the board issue an order for payment of the $50 civil penalty.
Second.
All in favor? Aye. All opposed? Motion carries. 15-CE-6246, Judith Trade.
The property has changed hands and has a new owner, so we're asking that the order that the board found at a prior hearing that the property was in compliance be set aside due to the fact there's a new property owner.
That was the order the board entered, was executed February 19th by the chairman, and it would be just to rescind that order.
Okay.
So it's not in compliance? Or
It
is
has a new owner. It changed hands, so it starts all over with a new owner.
Okay, but it's not in compliance even though it's with a new owner, right?
Correct, but it's a new owner that it'll be addressed with the new owner.
So you haven't cited the new owner yet?
I have not.
Okay. But it's not in compliance?
Probably not.
Oh, okay.
Just a little further background. The former owner lives in Illinois, so there's just really no way to enforce against that owner for the past violations. So Melody will be taking it up with the new owner as far as getting it corrected.
Okay. Well, I'll make a motion that the board rescind the order concerning this property from February 19th.
I second that.
All in favor? Aye. Motion carries. That was it. Oh, no. Attorneys matters.
What?
Yeah.
I just wanted to give you a heads up about the what the city has classified in the code, in the zoning regulations, as guest house and transient quarters. They're more generically called vacation rentals, short-term rentals. As you may remember, the city was being attacked basically on two fronts. One was a lawsuit for injunctive and declaratory relief by an owner of at least 3 guest house and the vacation rentals. And also the same person and another person challenged the interpretation of the zoning regulations involving those uses, and went through the process with the planning director, through the planning and zoning board for an appeal, then to the city council for appeal, and then the city council's decision upholding the interpretation of those regulations was appealed to the Circuit Court Appellate Division, which is still pending. But in the lawsuit for the declaratory judgment, the plaintiff there had 4 issues that they brought up, and it really was geared around the amendments that were made in 2015 to the code, where there was some definitions added, some minor tuning up of the regulations, but no overall changes. And what they challenged was, in 2011, the Florida legislature adopted, again, as you may be familiar, a statute that says local governments can't regulate their zoning when it comes to these vacation rentals, that you can't restrict the duration. And one of the things that was added to the code was what we can, as lawyers, that are familiar with it, call it really just an evidentiary device, where we said that there's a presumption that if you're renting for less than 30 days, it's not proper. It's a guest house transient quarter. It's transient. Well, anyway, the plaintiffs on their 4 different counts attacking that ordinance amending, they didn't really attack the fundamental regulations that go back to the 1970s, which I don't understand that. But anyway, they didn't. The court, they filed a motion for summary judgment, which means the court could rule without a trial because there was no issues of material fact there was no dispute about the facts. And the court ruled against the plaintiff on all 4 of the counts. And just Monday, our outside counsel, Mr. John Frost from Bartow, he requested and was in front of the court with a motion to just enter a final judgment, because the court's ruling on the 4 issues that the plaintiff had brought up basically really ended the case, because that took care of all the issues. The judge ruled for the city on every one of the issues. So on Monday, the judge did approve and granted a final judgment for the city in those cases, upholding, again, the basis of that was the 2015 amendments. But the ruling even goes into the prior regulations, the ones that are been on the books forever and are still on the books. So we feel really good about that. The plaintiff there can certainly appeal to the 4th District Court of Appeal. In that case, if they do, enforcement will still be held up for a while until that's determined. And enforcement against that particular violator is still held up also because of the appeal that's still pending about the interpretation by the City Council. So it's being attacked on 2 different fronts, but they've lost on the one. We feel fairly confident that they're going to lose if they do appeal, and it's going to be another waste of money for them. But I just wanted to bring you up to date and let you know that it appears we're on pretty good ground as far as the local circuit court goes, as far as the enforceability of the vacation rental ordinances.
Got a question.
Sure.
Do they have a tax number, and are they paying taxes on what they're?
We don't care if they do or not. They don't need one because it's an illegal use of the property. They can get all the state permits they want. It still doesn't make it legal in the state, in the city of Vero Beach.
Your mic.
They still need to do that. even if they're...
They may have. It's irrelevant. It's irrelevant to the city's case.
Yeah, but I was just wondering if you knew that or not.
They may have. But that's just more evidence that they're violating the zoning regulations.
Wayne, how many properties are involved?
Well, there's only one where this particular individual was cited, but he freely admits he has at least 3 in the city. And the other one that didn't file the lawsuit but does have an appeal, I'm not sure if that's just one property or what. Unfortunately, when you get into the appellate system, that takes even longer than the trial system. So, but just like the prior case that went to the circuit court appellate, that type process is very limited in what the appellate court looks at as far as the administrative decision, like of the city council, where those 2 individuals have attacked that interpretation made by the city council, upholding the Planning and Zoning Board, which upheld Mr. McGarry, which basically upheld the interpretation used by the code enforcement officer. There, they only look at whether or not due process was provided, whether or not the decision is supported by the record from the hearing in front of the city council, and did the city council follow the law. We feel pretty good there that when they only look at those 3 things, the record is very clear that the city council's decision should be upheld. So that one, hopefully we'll get a good result for too much longer, and then we'll see if they appeal the declaratory action case to the 4th DCA. That one, still, the court is going to look at the record, and we think that the court's decision here locally was well-founded, and the final judgment should go into all the legal ramifications and be well-supported.
Are they still renting these while this is...
Oh, yeah, I'm sure they are. Yeah.
I see them.
Sure they are.
I see quite a few of them.
Yeah. And then if everything's upheld and they get to come back in front of you, you get to decide if there was a violation. I just want to bring you up to date on that and let you know that it is working through the system.
And if we find them in violation, does it go all the way back to when they started, or just that
Let's
point?
talk about that at the time.
Okay.
I'm sure they'll have their arguments the other way.
Oh, yeah.
I would imagine. Anybody have anything else? And we'll adjourn. Thanks.